So today the Supreme Court ruled that prosecutors are permitted to have a police officer testify as to what a defendant is thinking. Stay tuned to hear why you should be terrified of this ruling and how it can affect your life. This is by far the biggest hit to people's rights by this court in at least 2 years, and it's important. Welcome back to the channel and thanks for watching. My name is Attorney Stanley Helinski, and this is where you can learn about legal issues that affect your life. I've been a practicing lawyer for about 25 years, as well as a law school professor. Now that we have YouTube, I don't really need a classroom to teach law, and you don't need to take the LSATs to learn. I have a quick one for you today. Most of us know that the Supreme Court has been doing some pretty radical things lately. This decision we're talking about today is a doozy, and lawyers are absolutely flipping out over it. The name of the case is Diaz versus the United States. In it, the court strips down nearly 50 years of law by holding that a police officer is now able to testify in a criminal case that essentially the defendant intended to commit the crime. This is absolute rubbish, and even one of the most conservative justices on the bench voted against it and wrote a pretty damning dissenting opinion in the case, saying why he thought this took away people's long-held rights. So how does this affect your life and why should it matter to you? Let me explain. There's a rule in every case that prohibits a plaintiff in that case, so in a criminal case that's going to be the government, from having a police officer testify as to his or her belief as to what the defendant was thinking at the time of the alleged offense. In just about every criminal case, the government must prove that the defendant had what's called mens rea, it's a Latin term, or evil mind, also referred to as intent to commit the crime. Mistakes, negligence, and accidents generally don't fall into criminal statutes. Though if you didn't intend to shoot someone, but you intended to shoot a gun, and that gunshot killed somebody, you're still on the hook because you intended to shoot the gun. So your intent is still there, but the intent is focused on the shooting of the gun. Either way, the government must prove intent. That rule just makes sense. If the government has to prove that you shoplifted, they can't call a police officer to the stand to say that you intended to steal something from a store, rather than forgetting it was in your basket or whatever other 100 reasons you may have. It's a no-brainer, right? Well, that all changed with this decision. What the court just did was to say that a police officer may come into court and to testify that most people who commit a crime would act in a manner consistent to the defendant. So staying with our shoplifting example, a police officer may now come into court and testify that most people who intend to steal something from a store will take their basket with them as they leave the store. Or that most people who steal something from a store will purchase a number of other items and then claim that he or she forgot it was in the basket. Whatever your explanation may be, an officer or other witness for the government may essentially tell a jury that your explanation is bogus. So much for innocent until proven guilty, right? So why should this matter to you? Our entire system of government, the Constitution and all that, is solidly built on the premise of being innocent until absolutely proven guilty. We all know that. What the U.S. Supreme Court did in this case is absolutely the opposite of that principle, and the rulings of the U.S. Supreme Court apply to every single person in this country. This is the absolute highest court in the country, an entire branch of government. They make law that applies to every single person. If they say you should leave the country, you have to leave the country. If they say you can't own a house, you can't own a house. If they say you can't get an abortion, you can't get one, as we saw in the Dobbs case. So this, quote, highest court in the land issued this Diaz decision this week that is exactly opposite of the rights that make this such a great country. And these decisions are becoming a habit of this court. It should scare the crap out of you. It scares the crap out of me. This Diaz case is now the law of the land, and it absolutely cut back on your rights and freedoms. For those who enjoy legal analysis, let me tell you about the case. So this woman named Diaz was stopped coming over the border to the United States. When she was stopped, border agents searched her car and found a large amount of meth under the car. So she was charged with, among other things, trafficking drugs into the country. Those were the basic facts of the case. Now, you always need to hear the other side of the story. People often ask me, like, how do you defend criminals? And my answer is always the same. How do you know the criminals? I never know. I listen to their story and decide. Well, Diaz's story, her defense in this case, was that she had no idea that the drugs were under the car, and that it wasn't her car. Typically, the jury hears all of the evidence and then decides as to whether they believe her or not. And that will dictate whether she's guilty or not guilty. If she didn't know they were there, then there's no mens rea, evil mind or intent to break the law, and she cannot be convicted. So these are the very basic set of circumstances. In this case, the jury decides if the government proved that the defendant knew that the drugs were under the car. This same set of facts happens probably 1,000 times a day in this country in these cases. Courts have been hearing these kind of cases for centuries. Well, the prosecutors in this case, in the Diaz case, wanted to win the case. So they offered to have a police officer who wasn't anywhere near the defendant when she was arrested to come into court and to say there was no way that she would have known that the drugs were there, because any dealer with that much meth would never leave the drugs with someone who didn't know they were there. Well, Federal Rules of Evidence 704, enacted in 1975, unambiguously states that, quote, an expert must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged, or of a defense. Those matters are for the trier of fact, the jury. Well, the government in this case needed to prove that Diaz knew that the drugs were under the car, and the government wanted this police officer to testify that Diaz must have known that the drugs were under there, because any dealer of such drugs would never leave Diaz alone with the car without some agreement as to what would happen to them, to the drugs. I mean, isn't that exactly what Rule 704 prohibits? Testimony as to the defendant's mental state. Well, not so much. The judge did allow the police officer to testify that most drug dealers would never give up possession of that much drugs to someone who didn't know that the drugs were there, that weren't involved in the plan. So how in the world is that not saying in so many words that Diaz knew that the drugs were there? Well, she was convicted. I'm sure she's serving a very long jail sentence right now. After she was convicted, the case went all the way up to the Supreme Court. If you don't know, the Supreme Court takes only about maybe 100 to 150 of the more than 7,000 cases a year that it's asked to review. I mean, I'm a lawyer, not a mathematician, but my calculator says that amounts to 0.02 of the cases that the Supreme Court is asked to review that they actually take. A tiny, tiny number of cases, relatively speaking. Well, the Supreme Court held today that this testimony was permitted, that the trial court judge was correct, and that in all future cases, the government may call a police officer to testify as to what most people in a certain demographic think, because the police officer is supposedly an expert as to what people think, right? Well, when you play this out, that means that a police officer may testify that most people who carry an ounce of marijuana are dealers, or most people who carry a knife intend to stab somebody with it, or most people who get drinks with another person in a bar and then have sex with them intend to rape that person. So you can see how horrifying this decision is. Say you meet someone in a bar who has maybe some mental illness that you didn't realize. You have some drinks with that person in the back of your apartment, you're intimate with one another, it's 100% consensual. However, consider this. The other person finds out the next day that she's pregnant, and she lives in a state where she can now only have an abortion, and I'm not commenting on whether abortions are good or bad in this whatsoever, but she finds out that she's pregnant, and because of other recent Supreme Court decisions, she lives in a state where she can only get an abortion if she got raped, because she personally sees having a baby as ruining her life. This person now has to choose whether to ruin her life or to ruin yours. What do you think she's going to choose? So the next day she goes to the police station and she says that you raped her. Well, you get arrested, she gets the abortion based on her allegations, and now she has to keep her story all the way through trial or she'll get in trouble for lying. But the government, looking at the case, don't think they have a strong enough case to get you convicted, and they want to get you convicted because they believe you raped her because she said you raped her. So at trial, they'll have a police officer tell a jury that most people who get someone drunk in a bar are looking to rape them. That's what this decision says. What can happen to your life just from meeting someone at a bar one night? It could be absolutely destroyed. A young man coming up in finance, having graduated from prestigious college, is now serving a lengthy jail sentence and is a Class A sex offender. The overreaching effect of this decision is unimaginable. If this person who got pregnant had to choose between what she perceived as ruining her life versus ruining your life, that's going to go against you 100% of the time. So that's where we are in this country with this Diaz decision. Justice Gorsuch, U.S. Supreme Court Justice, who is a very conservative, certainly not liberal, Justice of the Supreme Court, angrily disagreed with this decision. Justice Jackson, a very liberal judge, voted for this decision as well. The walls of the Supreme Court are truly crumbling. So please, please pay attention to what's happening up there. Write your legislators. Get your voice out there. Join this channel. I'll always comment on these kind of cases and post a video about them, so I'll be able to keep you up to date on the important decisions that could seriously affect all of our lives. Let me know your thoughts about this decision in the comments. Tell me what you think needs to be done. This is really, really serious stuff. There's so much news these days that these decisions like these, don't always get picked up and reported on. But you need to be aware before you do something innocently that could flush a good part of your life. So please help out this channel and like this video. Thank you as always for watching. And if you want to know what to do when you're pulled over by the police after you've had a couple drinks, watch this video next.